So we can start.
Okay. Resume today.
Where is the claimant counsel? Okay. Is the claimant counsel around? Huh?
It was on live a while ago. It was online a while ago. I don't know. It's now.
Okay. Call the case then.
Resume today, Thursday, 30th day of July 2026, before his lordship, however Kola-Olalere. Case number 1. And Islam, State Islam 2021 between Sonny Oyobuchi and Chief Robert Esquire, provisional liquidator of the Lone Star Reading Nigeria Limited. My Lord, parties absent.
Parties absent.
Yes, my Lord.
Counsel? Counsel?
It appears my learned friend was online earlier, my lord. If I may announce my appearance,
Yes, you can.
Aloysius Ezenduka, my lord. My appearance is for the defendant.
Okay, the claimant counsel has come online now. So let me take his own. Mr. Abadi.
Yes, my lord.
Yes, announce yourself, please.
Lord, with profound respect to this honorable court, my Lord J.S. Abadi. J.S. Abadi for the claimant respondent, sir. Most grateful, sir.
Yes, Mr. Aloysius, you can now announce your appearance.
Scott, please. Most respectfully, my lord, Aloysius Ezenduka. Aloysius Ezenduka. My appearance is for the defendant applicant.
I want to start my ruling. Court ruling. The claimant instituted this. Yes? What?
Nothing, my lord. I said as court pleases.
Oh, okay, okay. The claimant instituted this suit against the defendant on March 24, 2021 by way of complaint seeking for the following reliefs. a declaration that by the contractual agreement between the claimant and the defendant via letter of promotion and confirmation of appointment dated 1/2/2012, the claimant is entitled to the agreed monthly salary of $7,000 throughout the period of August 2013 to March 2014. 2, a declaration that the defendants are indebted to the claimants in arrears of salary for 8 months, that is from August 2013 to March 2014. 3, another directing the defendants to pay the claimants the sum of $56,000.
This editors.
What? James, you are disturbing me.
I'm checking. I can come down.
James.
Yes, my lord.
You are interrupting the proceedings.
Sorry, my lord.
Why are you interrupting the proceedings?
Sorry, my lord. Sorry, my lord.
3, another directing the defendant to pay the claimant the sum of $56,000 only, being unpaid salaries, actual debt, allowances, entitlement, etc., owed the claimant by the defendant for the period of 8 months, from August 2013 to March 2014. 4, interest on the said sum of $56,000 only at the rate of 20% per annum from August 2013 till judgment is delivered, and thereafter at 10% interest rate per annum until judgment sum is fully liquidated. 5, the sum of 2 million naira only, being general damages for various psychological trauma, emotional stress, economic hardship, loss of father due to illness. Loss of father to illness due to inability to afford medical attention, etc., suffered by the claimant as a result of the neglect or refusal of the defendant to pay the claimant's outstanding arrears of salaries. 6, the sum of 1 million naira only, being professional fees paid to the lawyer for the prosecution of this matter. On June 15, 2026, counsel to the defendant proceeded to adopt his addresses on 3 pending motions before the court. The first one was filed on May 12, 2026 at pages 690 to 702 of the court record. The second was filed on October 22, 2021 at pages 88 to 132 of the court record, and the third was filed on January 15, 2024 at pages 395 to 409 of the court record. The first motion on notice of the defendant, which was filed on May 12, 2026, was brought pursuant to Order 2, Rule 2, Sub 5, Order 5, Rule 2, Sub 1, Order 15, Rule 8, Sub 1, Order 26, Rules 2, 3, 2, 4, 5, and 6 of the National Industrial Court of Nigeria Civil Procedure Rules 2017, and order the inherent jurisdiction of this honorable court. The motion is praying for another striking out the claimant's amended general form of complaint, and all the accompanying court processes dated April 16, 2026 for incompetence. The motion is based on 7 grounds as adumbrated on the motion paper and supported by an 18-paragraph affidavit deposed to by one O.J. Shakaho, a legal practitioner with Perkins solicitors representing the defendant in this case. Also, a written address was filed in further support of the motion, wherein counsel formulated an issue for determination of the court as, and I quote, whether the claimant's amended originating process in the light of the amendment to it without the leave of the court and non-compliance with Order 26, Rule 6 is competent and ought to be struck out. Let me leave all the arguments on this application as presented by counsel. Okay, so I'll move to then to that application. The claimant did not file any counter affidavit or written address in opposition to the application. Now I go to the decision part of that on that first motion. I've carefully examined, I left out all your arguments on the application, but when you get a copy of your ruling, you are going to see the summary of your argument in the ruling. I hope counsel will understand me. Oh, you agreed? Okay.
Yes, my lord.
All right. Now I go to the decision part of the ruling on the first motion. I have carefully examined the motion, the affidavit in support, the exhibits attached thereto, the written address of counsel, and the entire record of proceedings. From all of this, the sole issue for determination is, and I quote, is the claimant's amended general form of complaint together with its accompanying processes filed on April 16, 2026 competent, or it should be struck out. Before addressing the substantive application, it is necessary to state that the absence of a counter affidavit does not automatically entitle an applicant to the relief sought. The law remains that an applicant must succeed on its own strength of on the strength of his own application and establish its entitlement to the relief sought. A cited authority is referred to there. The first objection of the defendant against the amendment was that it was effected outside the period contemplated by Order 26, Rule 6 of the rules of this court. Order 26, Rule 6 of the NIC and Civil Procedure Rules 2017 provides, and I quote, if a party who has obtained an order to amend a process does not amend same within the time allowed for that purpose by the order, or if no time limit is fixed, and the party fails or neglects or is unwilling to amend as ordered within 14 days of the date of the order, such party shall pay penalty. End of quotation. It is significant to note that the rules itself prescribe the consequence of default, which is the payment of a monetary penalty. In essence, it is clear from the content of the rule as reproduced above, which the rule relied on by the defendant as produced above, that it does not provide that such amendment out of time shall be void, incompetent, or be struck out. The law is tried that where a statute or rule of court prescribes a specific consequence for non-compliance, a court ought not to import a different consequence. In this instance, therefore, I find an hold that mere lateness in effecting an amendment without more does not render the amendments a nullity. And so the defendant's prayer for striking out of the amended processes for filing same out of time is accordingly declined.
As a court pleases.
Yes, as the court pleases. You say that. If you say that, I know that you are listening to me. But if you don't say that, it means you are not following. Okay. The second basis for the first application against the claimant's amended processes is that he exceeded the scope of the law granted by the court in the amendment. I've examined the affidavit evidence and the processes complained of, assuming that certain portion of the amendment went beyond the the substitution expressly authorized by the court, the question remains whether such excess renders the entire processes incompetent. The answer in my respective view is in the negative. Order 5, Rule 1 of the NIC and Civil Procedure Rules 2017 makes provisions for instances where a party, before it may fail to comply with any of these rules. To a considerable extent, such failure may be treated as an irregularity, and the court may give necessary direction on how to rectify it or do the needful. It is the practice of this court to interpret and apply these rules in manners that gives effect to the objective of fair hearing, speedy dispensation of justice, and giving of substantial justice. Furthermore, Order 5, Rule 3 of the NIC and Civil Procedure Rules 2017 empowers the court to even depart from these rules where the interest of justice so requires. In addition, Section 12, Sub 2, Paragraph B of the NIC National Industrial Court Act 2006 equally allows the court to regulate its procedure and proceedings as the justice of the court demands. Also, the Supreme Court has repeatedly warned against sacrificing justice on the altar of procedural technicalities. A cited authority is referred to there, where the court emphasized that a court of law should not be unduly tied down by technicalities, particularly where no miscarriage of justice would be occasioned. Similarly, another decided authority is referred to as a court of appeal decision, where the court reiterated that modern adjudication favors substantial justice over technical justice. The present suit commenced on March 24, 2021, and parties had already exchanged pleadings. The application now before the court seeks to strike out the entire amended process and thereby potentially defeat the determination of substantive labor dispute on its merit. In my firm view, such an order would be disproportionate to the procedural infraction alleged. This is more so because in all the arguments of the defendant counsel, I'm able to find that the defendants have demonstrated that any substantial miscarriage of justice was occasioned against them by the error complained of in the amendment. The authority cited by learned counsel on the obligation of court to obey court order, which includes Nyako versus Adamawa State House of Assembly citation supplied and Okobi versus Okobi citation supplied. They are correct, and they correctly state the law, and this court agrees entirely with the court order, entirely that the court order must be obeyed. However, I'm of the considered opinion that the sanction of every disobedience of court order is not automatically striking out of the process or the dismissal of the claim made in disobedience. In deciding the appropriate sanction on every disobedience of court order, the court must always consider whether the end of justice will be better served by such sanction. Having carefully considered the provisions of Order 26, Rule 6 of the NIC and Civil Procedure Rules 2017, the age of this suit, the nature of the claim involving alleged unpaid salaries, and the overriding objective embodied in Order 5 of the rules of this court, I am not persuaded that striking out the entire amended process will serve the interest of justice. It will literally mean throwing away the newborn baby with its bathwater, and it will unreasonably further delay justice. This is my finding and holding on this point.
As the court pleases.
Okay. in addition, I hold that the delay in effecting the amended and the expansion of the amendment beyond the scope of the leave granted constitute procedural irregularity capable of being remedied under Order 5 of the NIC and Civil Procedure Rules. Accordingly, I hold that even though the defendant's motion of notice filed on May 12, 2026 for striking out of the amendment of the claimant's complaint and statement of fact because it was effected outside the period contemplated by Order 26, Rule 6 of the rules of this court, and because the claimant exceeded the scope of the leave granted by the court in its amendments, I decline from striking out and discountenancing the whole process. The above holding notwithstanding, the court cannot ignore the claimant's failure to comply promptly with the order made on December 9, 2025 in respect of the amendment in question. The delay for several months before effecting the amendment is inexcusable. This, in my view, resulted in avoidable proceedings. Resulted in these avoidable proceedings. Again, amending the processes beyond the scope permitted by the court is not permissible by the rules of this court. Consequently, I hereby direct the claimant to pay adequate penalty for the delay in filing as contemplated under Order 26, Rule 6 of the NIC and Civil Procedure Rules 2007, which is to be properly assessed at the registry of this court.
As the court pleases.
Again, pursuant to Order 55 of the NIC and Civil Procedure Rules 2017, I hereby award the sum of 250,000 naira cost against the claimant's counsel and in favor of the defendant's counsel for the needless delay and procedural non-compliance by the that necessitated this application. I further direct the claimant's counsel to represent his amended processes only as granted him by this honorable court on December 9, 2025, failure of which would definitely attract further sanction against the counsel.
As court pleases.
Ruling on the first motion on notice of the defendant filed on May 12, 2026 is entered accordingly.
As court
pleases.
Now I move to the second motion. The second motion on notice of the defendant filed on October 22, 2021 at page 18 of the court record. The defendant filed this motion on notice on October 22, 2021, pursuant to Order 5, Rule 2 and Order 15, Rule 1 of the National Industrial Court of Nigeria Civil Procedure Rules 2017, and under the inherent jurisdiction of this court, seeking principally for another dismissing dispute on the ground that it is statute barred under Section 16 of the Limitation Laws of Rivers State, Cap 80, Laws of Rivers State, 1999. In the alternative, the defendants are seeking for another stay further proceedings in this suit on the ground that the first defendant is under receivership procedure pursuant to an all-asset debenture in favor of a secured creditor, and that the second defendant was appointed receiver by the Asset Management Corporation of Nigeria, AMCON. This application is supported by a 13-paragraph affidavit and a written address wherein the defendant counsel formulated issues relating to limitation of action, effect of receivership on the maintainability of this suit, and the effect of sanction the effect of sections 34 and 35 of the AMCOM Act on the claimant's claim. The claimant opposed the application by filing an 11-paragraph counter affidavit with a written address deposed by himself at pages 142 to 204 of the court record. His counsel argued that the claim for salary, wages, and that of employment entitlement are not defeated by limitation of statute. He went on that receivership neither extinguishes the legal personality of a company nor prevents actions from being commenced against it, and that the provision of AMCOM Act relied on by the defendants do not operate to extinguish or suspend claims for wages and employment entitlement. He further relied on the proviso to section 48, sub 7, paragraph A of AMCOM Act. The defendants orally replied point of law during adoption that the counter affidavit filed by the claimant on December 3, 2024 was filed out of time without leave of court and urged the court to discountenance it. Now I go to court decision on this second application. Having carefully considered the processes filed, the affidavit, evidence submitted, submissions of counsel, and the applicable law, I am of the view that issues arising for determination here are: 1, is the action statute barred by virtue of section 16 of the limitation law of Rivers State? 2, do the receivership of the first defendant and the appointment of the second defendant by AMCOR as provisional liquidator on August 11. Just a minute, please. On August 11, 2023, deprive this court of jurisdiction or warrant a stay of proceedings until the conclusion of the receivership procedure? What is the effect, if any, of the alleged irregular filing of the counter affidavit? And now go on to resolve the issue. Issue 1 as framed is this action statute barred? The settled law is that in determining whether an action is statute barred, the court will examine the originating processes, particularly the statement of fact, and the relief sought so as to ascertain the nature of the claims and when the cause of action accrued. Some decided authorities are referred to there. The defendant contended that the claimant's salaries becomes due between August 2013 and March 2014, and that this action was commenced in March 2021, which is outside the 5 years limitation period allowed by section 16 of the limitation law of Rivers State. The claimant, however, argued that the claims are for unpaid salaries and employment entitlement and are not caught by limitation laws. On this issue of limitation of action by provision of section 16 of the limitation law of Rivers State, it is my considered view that the main claim of the claimant from his complaint, and the statement of fact is for the salaries of 8 months that he had already worked for the first defendant, and the first defendant failed or refused to pay for the said services he already rendered as agreed by the parties. If the alleged agreement is proven to be true, and it is also proven that the claimant actually worked for the said period under agreement in question, and that the fraud defendant is also shown not to have kept his own part of the agreement by paying the claimant wages after it has enjoyed its services under the agreement, the substantial justice in such situation is to allow the claimant to enjoy the fruit of his labor. Therefore, I find in the circumstance that it would be unfair and inequitable to just shut the claimant out at this stage without even allowing him to prove his claim if the only problem here is that the claimant claims this later than the time allowed by the law in a private employment and nothing more. Not even that there is any miscarriage of justice or any loss to or against the defendant by the said lateness. Therefore, based on the provisions of Section 254C1F of the Constitution of the Federal Republic of Nigeria, 1999, as amended, which give this court jurisdiction over unfair labor practice, and based on equitable provisions in sections 13, 14, and 15 of the NIC Act 2006, I hold that it would be unfair and inequitable to bar this case from adjudication from the provisions of with the provisions of Section 16 of the Limitation Law of Rivers State. Besides, the authority relied on by the claimant concerning continuing injury, particularly the case of CBN versus Amao, citation supplied, will merit serious consideration in relation to unpaid salaries and employment. I further hold that through throwing this case away, as prayed for by the defendant, will rob the court of this jurisdiction. Consequently, I hereby resolve this issue of statute bar against the defendant.
As God pleases.
As God pleases.
The issue two as framed under this motion is on whether receivership and the AMCON appointment deprives the court of jurisdiction or warrant stay of proceedings. The defendant contended that the appointment of the second defendant as receiver over the asset of the first defendant prevents the claimant from maintaining this action. On this, the leading authority remains Intercontractors Nigeria Limited versus National Providence Fund Management Board, citation supplied. In that case, the Supreme Court emphatically held that the appointment of a receiver does not extinguish the legal personality of a company. A company in receivership remains capable of suing and being sued until it is wound up and dissolved. Oputa JSC further stated that if a company can sue after receivership, it can equally be sued after receivership. The Supreme Court again held that issues relating to priority between secured and unsecured creditors arise only after judgment and not at the stage of determining whether an action can be maintained. Similarly, in the case of Nekonde Energy Limited versus Fengos Merchant Bank Limited and others, citation supplied, the Supreme Court held that the fact that a company is under receivership does just a minute. The court held that the fact that a company is under receivership does not translate to the death of the company, as the company enjoys a corporate personality. Therefore, the company will not lose its corporate personality until it is completely wound up. Another decided authority is referred to there. To this effect, I hold that the argument advanced by the defendant regarding the ranking of creditor is therefore prematured.
As the court please.
As court, please.
The reason being that this present suit is not an execution proceedings against any identified asset covered by the debenture. It is a substantive action seeking judicial determination of alleged employment right. The court cannot shut its door against an employee merely because the employer has gone into receivership. By virtue of the provision of Section 254C of the Constitution of the Federal Republic of Nigeria as amended, this court is constitutionally vested with exclusive jurisdiction over law, labor, and employment disputes. That jurisdiction cannot be displaced by any speculative arguments regarding eventual priority of debts of the first defendant, and I so find. The defendant also relied on Section 34 and 35 of AMCON Act. I have carefully examined these provisions and find that the sections confer right upon AMCON to acquire eligible bank assets and security. The sections do not provide that employment claims cannot be commenced against a debtor company while that proceedings is on. More importantly, Section 48 sub 7 paragraph A of AMCON Act contains a proviso that claims relating to wages and other entitlements of existing staff shall not be stayed. The legislative intention in this instance is very clear that employment-related claims occupy a special position and are expressly exempted from the stay mechanism contemplated under the Act. In the circumstance, I find that there is no legal basis for the court to grant the alternative prayer of the defendant for a stay of proceedings. Therefore, I hold that issue 2 lacks merit and it is hereby resolved against the defendant.
As the court pleases.
As court, please.
Issue 3, still on the same motion. That's the second motion. That's on the effect of the alleged irregular filing of the counter affidavit. The defendant argued in the reply on point of law that the counter affidavit was filed out of time without leave of the court. Even if there was any procedural anomaly in the filing of the counter affidavit, the question is whether such wrongdoing is sufficient to defeat the determination of this case on its merit. Order 5, Rules 1 and 6 of the NIC and Civil Procedure Rules 2017 stipulates that non-compliance with any of the rules will be treated as an irregularity and that the court can depart from the provisions of the Evidence Act in the interest of justice and fair play. Again, the court is required to apply its rules in a manner that advances substantial justice and prevents technicality from defeating the determination of dispute on their merit. It is my finding from the argument of counsel on this application that no prejudice whatsoever was shown by the defendant to have arisen from the filing of the counter affidavit against them. It is more so as the issue raised therein have been fully addressed by the defendant in their reply on point of law. It is my firm view in this instance that this court can safely deem the counter affidavit and its accompanying written address as properly filed and served in the interest of justice under Order 5 of the NIC and Civil Procedure Rules 2007, as no miscarriage of justice was demonstrated by the defendant, and I so deem. I hold that this objection lacks merit and it is overruled. For all these reasons,
As
on the
pleasing.
second application, I hold on the second application as follows. 1, I decline from holding that the claimant's case is in a private employment formerly known as masters and servants on paid salaries, allowances, and employment entitlement is barred by Section 16 of the River State Limitation Law. 2, I hold that the receivership of the first defendant neither extinguished its legal personality nor prevents the maintenance of this suit against it. 3, I hold that the provisions of sections 34 and 35 of AMCON Act do not deprive this court of its jurisdiction to entertain the claimant's claim. 4, I hold that the alternative prayer for staying of proceedings is contrary to the spirit and effect of the proviso to Section 48, sub 7A of AMCON Act, and it is accordingly declined. 5, I hold that the objection of the defendant to the counter affidavit of the claimant on ground of alleged irregular filing is a mere procedural irregularity which does not occasion any miscarriage of justice and is accordingly discountenanced. Pursuant to the provisions of Order 5 of the NICN Civil Procedure Rules, I hold that the motion on notice filed on October 22, 2021 lacks merit and it is dismissed in its entirety.
As court pleases.
The third motion on notice. The third motion, who's that? James. James? James? May I know who is? Yeah, okay. Why are you disturbing the proceedings?
Sorry, my lord. It was the this I just came into the court. He was asking something. Sorry, my lord.
I don't like that. I don't like that.
Sorry, my lord.
I don't like that. One bit. And stop interrupting me.
Sorry, my lord.
The third motion filed on January 15, 2024 at page 395 of the file. The third application is the defendant's motion on notice filed on January 15, 2024, seeking primarily for an order striking out or dismissing this suit on the ground that the first defendant is in liquidation and or under the control of the provisional liquidator, and that the continuation of this action has become incompetent. It is supported by a 7-paragraph affidavit deposed to by one Regina Akiba, together with a written address. The claimant opposed the application by filing a 5-paragraph counter affidavit on February 2, 2024, and attached Exhibit Sonny, being an order of the Federal High Court dated January 19, 2024, granting leave to the claimant to proceed with this case against the first defendant, notwithstanding the appointment of a provisional liquidator. The counter affidavit, together with a written address, were filed at pages 442 to 455 of the court record. The defendant replied on point of law to the counter affidavit and raised objection to its competence on ground that same was filed out of time without the leave of court. having carefully considered the proceedings filed by the parties and, having carefully considered the processes filed by the parties and the submission of counsel, I adopt this issue, I adopt the issue raised by the defendant for the court on this point, on this motion, which is, and I quote, having regard to section 580 of the Companies and Allied Matters Act 2020, and the fact disclosed before this court, is this suit incompetent, academic, or liable to be struck out by reason of the appointment of a provisional liquidator over the default defendant? Before proceeding to the substantive issue. Yes? Before proceeding to the substantive issue. Thank you very much. It is necessary to address the contention of counsel to the defendant that the counter affidavit on February 2, 2024 was filed out of time without leave of court. I have earlier noted in this ruling that the NICN is a specialized court and established primarily for the determination of labor and employment disputes. Also, by virtue of Section 12, Sub 2B of the National Industrial Court Act 2006, this court is empowered to regulate its proceedings as it considered fit. And in doing so, it is not strictly bound by technical rules of evidence as it can depart from such rules where the interest of justice so permits. In addition, Order 5, Rule 1 and Rules 1 and 6 of the NICN Civil Procedure Rules 2017 enjoins the court to apply the rules in a manner that advances substantial justice and prevents injustice. The court noted in the instant application that the counter affidavit introduced material facts touching directly on the jurisdictional issue raised by the defendant, particularly the procurement of leave of the Federal High Court, pursuant to Section 580 of CAMA. In the circumstance, it is my finding that striking out or discountenancing the counter affidavit would defeat the overriding objective of doing substantial justice in this case. Accordingly, I hereby overrule the objection of the defendant to the counter affidavit together with its attached exhibit. I further hold that this court will countenance the said counter affidavit with its attachment in determining this application. As court pleases, right?
As God pleases. I'm not so sorry.
Now resolving the substantive matter or issue on this third application. The defendant contended that the appointment of a professional liquidator over the first defendant renders the continuation of this suit incompetent and that the suit ought to be struck out. The applicable statutory provision in this instance is Section 580 of the Company and Allied Matters Act 2020, and it provides us, and I quote, if a winding up order is made or a provisional liquidator is appointed, no action or proceedings shall be proceeded with or commenced against the company except by the leave of the court and subject to such terms as the court may impose. End of quotation. It is clear that the effect of this quoted provision is neither to extinguish an existing cause of action nor to terminate the pending proceedings automatically. Rather, the provision merely requires that leave of the Federal High Court is to be obtained before such action may be continued after such appointment. A decided authority is referred to there, which is a Supreme Court decision where the court held that where a provisional liquidator has been appointed, leave of the Federal High Court must first be obtained before proceeding can continue against the company. The Supreme Court also reiterated the same principle in another cited authority here. You see it in your ruling, where Okoro JSC held that the purpose of the statutory provision is not to prevent proceedings against the company absolutely, but to ensure that leave of court is first obtained. Similarly, in another Supreme Court decision also cited there, you see it in your case, the Supreme Court said, the Supreme Court affirmed that proceedings against a company in liquidation may continue once the requisite leave has been obtained. The critical question, therefore, is whether the claimant obtained the requisite leave. Paragraph 3 of the counter affidavit expressly states that upon becoming aware of the appointment of the provisional liquidator, the claimant applied for and obtained leave of the Federal High Court in suit number FHC PH MISC 412/2023. The attached exhibit Sonny to the counter affidavit is the said leave, which is dated January 19, 2024. The defendants have neither challenged the authenticity of the order or leave from the Federal High Court, nor produced any other contrary evidence to this. The law is, as soon as the requisite leave contemplated in Section 580 of CAMA has been obtained, the foundation of the present application collapsed, and I so find the argument of the defendant that the suit has become academic or taste cannot stand in the face of the said subsisting order or leave of the Federal High Court expressly authorizing the continuation of this proceeding, and I so hold.
As the court pleases.
As the court pleases.
The court further noted that the claimant has taken an additional step by filing an application for substitution of the provisional liquidator, although that application is still pending before the court. It follows that rather than demonstrating abandonment of procedural requirements, the claimant has shown substantial compliance with the law, and I so find an hold.
As the court pleases.
As the court pleases.
The defendant also relied on the provisions of Section 575 and 577 of CAMA. However, those provisions deal principally with the matter relating to liquidation, proof of debt, and distribution of assets. They do not prohibit the continuation of a pending action where leave contemplated in Section 580 has already been obtained, and I so find and hold.
As the court
As the court pleases.
The question relating to ranking of creditor, proof of debt, and distribution of assets may arise at the stage of enforcement or liquidation administration. They do not constitute a basis for terminating the present action at this stage. This position accords with the reasoning of the Supreme Court in a cited authority here, where the court recognized that the appointment of a receiver or similar insolvency officer neither extinguished the legal personality of the company nor automatically prevents action from being maintained against it. We should bear in mind that this court is under constitutional and statutory mandate to protect labor rights and ensure access to justice in employment disputes. This claim is seeking for adjudication of this court unemployment-related claims. It is my firm view, therefore, that if this case is terminated notwithstanding compliance of the claimant with the provision of Section 580 of CAMA, it will amount to shutting the door of justice against a litigant who has obtained the prerequisite leave required by the relevant law. The action of the court will not accord with the overriding objective contained in Order 5 of the rules of this court, and I so find.
That's God blesses.
I hold that the appointment of a provisional liquidator over the first defendant does not render this suit academic, incompetent, or liable to be struck out in the circumstance of this case. For this reason, for the reason stated above, I hold that the defendant's motion on notice filed on January 15, 2024 lacks merit, and it is hereby dismissed.
As the court pleases.
On the whole, on this third application of the defendant, I hold as follows. I hold that the counter affidavit filed by the claimant on February 2, 2024 is deemed duly regularized before the court in the interest of substantial justice. The claimant is hereby directed to pay his due penalty for filing out of time, as will be computed by the court registry. 2, I hold that the claimant has complied with Section 580 of CAMA 2020 by obtaining leave of the Federal High Court to continue with this present action. 3, I hold that the appointment of the provisional liquidator over the first defendant does not render this suit academic incompetence or obtuse. 4, I hold that the defendant's motion on notice filed on January 15, 2024 lacks merit, and it is accordingly dismissed. Pursuant to Order 55 Rule 1 of the NIC and Civil Procedure Rules 2017, I hereby award cost of 250,000 naira against the defendant and in favor of the claimant for filing and arguing this unnecessary third application. These rules of the court on the 3 applications of the defendants, respectively, filed on May 12, 2026 at page 690, on October 22, 2021 at page 88, and on January 15, 2024 at page 395 of the court record accordingly entered. The rulings are accordingly entered. These rulings of the court on the 3 respective applications of the defendant in this case also abides in the other 4 sister cases with this case, with suit numbers NIC and PHC 39, 40, 41, and 42, 2021.
As the court pleases.
As the court pleases. My Lord, I just want to point out that it is only on 2 of the matters that leave has been obtained. So the ruling can only apply to the 47, I think 40, not on all of it, because leave has not been obtained in the other 3.
I based my decision on the argument before me. That distinction was not brought out. It wasn't brought out, and there's no how I can do that. So maybe when you are doing your final judgment, when you are doing your final argument, you can bring it out. But I based my decision on what was argued before me. And usually, you know, we say that whatever decision we do on the matter applies on the other sister cases. So you'll be thinking of how you will sort it out when you continue your argument on the matter. Okay.
Lord, we are very grateful for a well-considered ruling of this honorable court. Most grateful, sir.
So, you know, in essence, I awarded cost of 2,250 against each of you. So it balances each other. Nobody is paying anything. That's the idea.
As the court pleases.
As
Yes.
God pleases. My
Let
Lord, we
me
are grateful.
commend the Lord for. Let me commend the Lord for the industry that the Lord has put up in these rulings, and also pointed out. I point out that which I thought Mr. Abadi would have raised, that Mr. Abadi filed notice of this. I mean, withdrawing representation in respect of 2 of the 5 cases. So my thinking is that he will do well.
Mr. Nduka, all this one you are raising, we have not perfected it. I can't base my decision on what they just
As the
mentioned
court
that the
pleases.
court has not concluded on. If he
My
wants
Lord,
to
as the
do
court
that,
pleases.
maybe when we continue the proceedings, next time
Yes.
you bring it out properly, and I'll
As the
make my
court pleases.
decision
As God-
properly.
As the
I'll
court
close
pleases.
it. I
As
can't just do it like that.
As the court pleases.
As God
My Lord, we are
pleases.
grateful.
Yes.
At the appropriate time, you should do so.
You said?
My Lord, I said at the appropriate time, you should do
Yes.
so. Not today, yes, sir.
Mm-hmm.
As the court pleases. My Lord, we are grateful.
Mm-hmm. Okay, so now, Mr. Abadi,
My Lord.
you need to ask for a date now for
Yes, my Lord. My
for
Lord, in the
continuation of hearing or for what now?
Yes, my Lord. My Lord, in the circumstance, may we respectfully ask for a date. My Lord, for
Where were we before this tedious and strenuous applications came up? I think
My
we
Lord,
were
it
at
was
the point of adoption or what?
Yes, my Lord.
Even council have forgotten where we were because
No,
you
sir.
people
No,
stay
sir. No, sir.
so
My Lord.
much on this thing.
No, sir. My Lord, as for me, we never forget the stage where we are.
So
But
where are we?
my Lord, by my Lord's record, my Lord adjourned the matter after the grant of the Clement motion for substitution on the 9th of December 2025 for mention, sir. For mention, sir. Before the
With this
hearing.
ruling that has directed you to represent your amended process, you need to do that. You need to comply with that and amend your process in line with the leave granted you. Remove all the other extraneous things that you have added into that application. I mean, to your amendment.
Yes, my Lord. My Lord, already we have a pending motion before the hearing and determination of these 3 motions, sir.
Okay, you have represented the complaint?
Yes, my Lord. My Lord, we have filed a motion to regularize the issues raised by the defendant, sir.
Okay, no, the important thing I want to hear now is whether you have represented it, although we have not granted it. Is that what you are telling me now, counsel?
My Lord, ordinarily those paragraphs which the defendant raised that we amended beyond the scope of the order of the court. My Lord, those paragraphs are in tune with the order of substitution. Because if you are bringing in a provisional liquidator, you cannot still leave facts or maybe sentences that touches a provisional liquidator. Sorry, a receiver manager.
That's a different matter that you will now be telling that he has to react to. Okay.
As a court please. As God
So
pleases.
you're asking for another date for what now?
Well, maybe for further mention, sir. I don't know if that is the mind of my learned senior, sir. Hello,
You
sir.
tell me your own mind. You tell me his own mind when I come to him. You tell me your mind, what you want.
As God pleases, as God pleases.
Mr. Izendoka.
Yes, Lord. I think my learned friend should be aware that insofar the Lord has made an order pursuant to this ruling, for him to now comply with the order of 9th December, the proper thing for him to do is to file those processes in line with the subsisting order of this court. And then we can
Yes.
to
Before you now come with this other one that you're asking me that you have to amend the processes because something else has come up, right?
Yes, my Lord.
That's how you should go, Mr. Abadi, so that we not waste time again. Yeah. Do you understand?
Ordinarily, if my learned senior really wants this case to proceed, those paragraphs that he said we amended beyond the scope of, my lord, they are just immaterial. Immaterial, you can respond to it consequentially.
Listen, Mr. Abadi, you are the one that filed these cases. For goodness sake, since 2021. We ought to have finished this matter since 2023. But it's been one application or the other. No problem. Listen to me, Mr. Abadi. Just listen. The court has directed you now in a considered ruling, in considered rulings actually, that you should do the needful. Do what the court directed you to do. The court, you asked for one leave, and the court gave you that leave. Comply with that leave. Before you now bring this another application to amend it, you have to comply first. Do you understand me?
I don't understand. Just that, my lord, in the motion which we filed prompting the grant of the order for substitution, my lord, we all included relief for amendment. We all included relief for amendment, which
relief
my lord
for amendment
was granted. Yes, sir.
Did you state that you are amending XYZ?
My lord, ordinarily,
because what you asked for from the record, what you asked for from the record is relief. I mean, application for amendment to is it to change the name of the liquidator? Yes, to substitute.
Lord,
and the court granted you substitution.
Yes, my lord, the first.
So
then the second relief is for amendment.
I don't understand you, Mr. Don't let me be angry, Mr. Abadi. You had the ruling. You go back to your application where the court granted you leave to amend. Comply with that one first. Then you can break this other one. Oh, my lord, after complying with this one, I need to change the fact on this case. I mean, in this matter. So if you want, you can file two applications. One first comply, and then the other one, oh, I want to further amend. Then you look at it, everybody will be handled, and everything will be handled together.
As God pleases, as God pleases. But my lord, I need a clarification. Yes, sir. My lord, earlier before now, in view of the fact that the claimant was out of time to file its amendment pursuant to the order of my lord made on the 9th of December 2025. My lord, we did file a motion for extension of time earlier on and also paid the adequate penalty, sir. So, my lord, this new one now to file, my lord.
Was it moved? Was the application moved?
It's still pending before my lord.
Eh?
It's still pending before my lord, yes, sir. It's pending.
You didn't move it, so how do you want me to countenance that? But if you are, let me tell you, if you have filed and you pay penalty up to the time you filed, are you listening? Then you exhibit that. That covers it.
As God,
But
As court pleases.
you have to pay penalty from when you defaulted till when you filed.
As court pleases.
I'm not saying go and pay penalty up till now. No. You pay penalty up to the time you filed.
Well noted, sir. Well noted.
Okay. So, Mr. Zendoka, what's your take on this? He's asking for another day for further mention.
I wouldn't know the propriety of mention, because if he fights within time, serve us, we can as well. And in fact, my taking will have been that let us even adopt the final addresses that we have already filed. Because all we need to do now, we file this final written address and already sent copies to the court. The same person who is the professional liquidator is the same person who was the receiver manager that was sued. So all we need to do is that we remove the first page of our final address, refile it the second time, and we'll come back to adopt. Back and forth, for me, I think is we are making progress.
Counsel, I've been gracious enough to grant you people virtual sitting, right?
Yes,
that
yes,
is your movement from Lagos to Portharcourt, right?
Exactly.
So
exactly,
if he wants to regularize before presenting his final written address, let him do that. But you didn't just waste our time.
As God pleases.
This direction that I'm giving him, he can comply with that first one. Oh, my Lord, I asked for leave for this, and the court granted you leave. Comply with that, file that. Then you can file another process. Oh, my Lord, after looking at what I've just amended, there's a need for further amendment. You bring that one. The two can be handled together.
God blesses. As God blesses.
You understand? I'll serve the defendant on time so that whatever reaction that they're going to react to, they do that.
As God blesses.
So, right now, since all those ones are not in court, I cannot, are not before the court, I cannot adjourn for hearing of any further application.
As God pleases.
So he's asking for adjournment for further mention. What's your take, Mr. Nduka? Because I have to put you on record.
As God pleases, I have no objection to the adjournment.
Okay. No objection. James.
My Lord.
Check my diary for October.
Yes, my Lord, with the diary, my Lord. I will the diary. I will the diary, my Lord.
Tell me when we are starting and how many cases I have on each day, so that I know the one that is.
We started on 13th of October. I have 4 matters, my Lord. 13th.
Go to end of October. End of October. Let's see.
Okay, my Lord. My Lord, end of October, you have 29, 28, 29.
Mm-hmm.
We have 4 matters, 29, 4 matters.
What are they for now?
Okay.
What of 30? How many cases on 30 is what day of the week? 29
Friday,
is what day?
So 29 is a Thursday, my Lord. 28 is Wednesday.
So what?
28 is Wednesday, my Lord.
On Wednesday, how many cases do I have?
My Lord, I have 4 matters there. I have one at defense, abduction, report settlement, and hearing and defense.
Okay. What of the next day?
The 29, my Lord, have hearing, abduction, defense, and hearing. 2 hearing, 1 defense, 1 abduction, my Lord.
Four
Yes,
cases.
my Lord.
So,
yes,
Counsel, which of the dates is convenient for you?
My Lord, for me, 28, sir.
28?
Yes, sir.
Okay, Mr. Izendoka.
If the Lord will continue to indulge us with virtual hearing, 28 is convenient, sir.
28 is what day of the week?
Is the Wednesday?
My Lord, is Wednesday.
No, I don't take virtuals midweek. I am very busy with midweek. I only take virtuals on Mondays.
The Lord, 25th will be fine. 26th of October is fine, sir. If the Lord will accommodate us, which is a Monday, sir. And if it's okay for my learned friend.
26?
Yes,
I
my
think
Lord.
there is a program that I have to go for.
On
26. Mm.
If the Lord will look at the next.
virtual hearing.
When is that?
My Lord,
James,
26, my Lord have one virtual hearing by 11 o'clock. My
by
Lord,
11.
on 26th October. Yes, by 11
Okay.
a.m.
Okay. So can
And
you
then I
come
have
by
another
1?
2 hearings.
I have another full
Sorry, my
hearing.
Lord. My Lord have yes, 1 hearing and 1 adoption, my Lord.
No, let's take another Monday. What of the next Monday?
The next Monday is on November.
November 2nd.
November what?
My Lord, 2nd.
Okay. Is
November
that
2nd.
okay by how many cases do I have then?
My Lord, if it's still matter here too.
Eh?
One is continuation hearing, 1 adoption. My Lord, fix 2 matter here already here. 1 for continuation hearing, 1 for adoption. That's the old matters.
Is it virtual hearing?
No, it's not virtual, my Lord. It's a physical.
Okay, so we can take that at 1 o'clock, right?
I don't know if the law will accommodate us at 2 p.m. because I have a matter at the Federal High Court, Lagos on that day, but 2 o'clock will be fine if it is convenient.
Okay, 2 o'clock. Abadi, Mr. Abadi.
My Lord, it's okay. But just I thought we can do physical hearing this time around.
No, with all this, you're coming more for further mention, then you fly from Lagos.
My Lord,
Because
my learned senior said he is heavily paid. He made mention of it one day in court, sir.
there is no substantial justice in that one. To just come all the way from Lagos and fly up and down.
Said it, my Lord, he said it in the open court that he's heavily paid and all that.
And then you want to
no problem. No problem. We can do virtual.
Whatever he pays to the airline, it doesn't go to your purse anyway.
Do
you understand?
My Lord, we are fine by 2.
Don't mind Abadi. Abadi is interested in liquidating me to conclude this matter, sir.
Okay, what day of the week is that? What day of the week is that?
The Monday.
Another 2nd is Monday, sir.
2nd November, right?
Yes, sir.
Okay.
Most grateful, sir.
No, we are grateful, sir.
All right. This matter is adjourned to November 2, 2026 for further mention virtually at 2 p.m.
As God please. I wish the Lord a restful vacation, man.
Thank you very much.
Yes.
Okay. Bye.
Bye, man.
Okay. Okay, bye-bye.
Yeah, that's good.
Yeah. Okay. So what you say?